Hi, my name is Michael Kevin Archie. I'm Commissioner with the Cook County Board of Review. Thanks so much for being here. Sorry for the delayed start. A couple of housekeeping matters to take care of first. First of all, everything here is being recorded. Both the presentation you're about to see and your questions and answers, all of that will be available for download and viewing at the website of the Board of Review, cookcountyboardofreview.com. So again, the presentation and the Q&A will be available for download and viewing later at cookcountyboardofreview.com. That leads me to my second point, which is, as we were just told, there's a line of over 100 people out the door right now. We know there's a lot of interest as to what the board's rules are going to be for the upcoming session and new policies and procedures changes. So for those people who aren't able to watch it live, again, you're not missing anything to watch it remotely later. For those people who are coming in later, you can tell them they can jump online and watch what they've missed up to this point as well. So again, thank you all for being here today. A couple of matters I just want to make a point of. I want to thank the hardworking staff and leadership of the Cook County Board of Review. Last year was a record number of appeals filed at the Board of Review. The city triennial we knew was going to be demanding on the board. It really stressed us, but I couldn't be more proud of the staff. They work nights, weekends, holidays. As you know, they were picking up the phone late at night and on the weekends to answer your questions and to work with you. So hats off to all of them. Hats off to our chief deputies and our first deputies. Thank you. Similarly, I want to thank all of you. So our DAPS system, our Digital Appeals Processing System, is in its second year. In its first year of usage, it blew all of our expectations. More than 89% of the appeals filed last year, 89%, were filed online with the DAPS system. It worked well, but it didn't work perfectly, and we've made changes over the summer to continue its improvement. A lot of the policy and procedure changes you're going to see today are a result of feedback we got from you. So please keep it up. You're the users of the board and you're the users of the DAPS system, and we need to hear your feedback of how we can make it work more effectively and more efficiently. On our end, we're pleased, but we've made changes on how our analysts and hearing officers are going to use it. We want your feedback on how you, the user, can use it as well. So I'd like to introduce my colleagues. First, Commissioner Dan Patlick would like to say a couple words.
Hello, everyone. Good morning. Thanks for being here today. Last August, when we first started using the Digital Appeals Processing System, we at the board had a pretty good idea of what to expect because we had been working on developing it for 3 years. We know that you really didn't have a good idea of what to expect, and some things came as a surprise. But I want to thank you for your cooperation. We also want to thank you for your suggestions up front. As soon as you ran into various challenges and problems, you let us know. And as a result, we were able to make some improvements on the fly. One being the drop-down menu for evidence. I know we initially started with only a very limited number of items on there, and then due to what the attorneys had to tell us, we increased it and made it more detailed, and that made life easier for you and made life easier for us. As Commissioner Cavanargi said, since that time, since the close of the last session, we've made some additional improvements, and we are going to detail them now. I think you're going to really like a lot of the things that we've done because, again, they make your life easier and they make our life easier. But please, as we proceed through the year, let us know if you have some better ideas on how to improve our technology, and we're going to take them into consideration. So I want to just introduce Commissioner Larry Rogers. I think he has a couple of words to say as well.
This is the third thank you on behalf of the board. As you know, we're 3 commissioners, so we do things in threes largely. But the DAPS system, we've been very pleased with the results, pleased with the participation of citizens and the participation of the working bar. We've heard good feedback individually, but we want to hear both the good and the bad so we can improve it as much as possible. We had the option of doing this meeting in the other room, but they had no air. So I think you'd prefer to be here, even though So we dealt with a little bit of a security line. We do apologize for that, but we thought this was a better accommodation. Please, we do get some calls. I think there's more input that we could get from out there, from each of you who deal with the system. Don't hesitate to contact us. Don't hesitate to call. We want to make sure that the system works best for those who are using it and ultimately for the taxpayers. So thank you. We'll be around until the end of the session, so you can ask us any questions you may have or express any concerns you have. Thank you again.
Thank you. If this is your first time being here, Chief Deputy William here will be leading us in a presentation. Again, the presentation will be available for download on the website and reviewing later. So for those of you who have come in later, you can start the beginning and watch the presentation from the beginning and including the question and answers. So we're going to put questions off until the end, and William's going to do the presentation as well. Thank you.
First and foremost, good morning. And I'd like to thank everyone for their patience. I realize that the room accommodations weren't exactly the best. However, as Commissioner Martin did point out, we do have air, and it's about 95 degrees outside. So let's get started. Today, we're going to talk about different procedures that have been revised for the 2016 session. There have been a few rule changes, nothing major. As Mr. Pavlik did describe, there were certain enhancements implemented, and this was based on the feedback that we received from both the practitioners as well as individual taxpayers. And then there's some things that we did learn during the course of the session, and we consider them do's and don'ts in regards to the DAPS system. It's been stated that this presentation will be available on our website. Now, in more detail, we'd like to talk about, again, rules revisions, certain board forms that have been revised. Particularly, we want to look at the substitution procedure, the revision of the evidence submission deadline, and we want to remind you about the importance of registry for account enhancements. And this is new for 2016, the board's acceptance of digital signatures, particularly for the attorney authorization forms, and we'll provide more detail in regards to what exactly is a digital signature. And one of the things that we were looking at is when there's a requested no change to exhaust administrative remedies. In years past, that was reason code number 4. But also, there was some confusion that reason code number 4 was also if there was a pending PTAB or if the board's relief held from the previous year. So to distinguish that, we came up with a new reason code 8, and that's to exhaust administrative remedies. And we'll have more discussion in regards to that, where you can request the administrative no change through the court. Also, in regards to Rule 15, a lot of, particularly sections 1 and 2, it dealt with a paper-based system, particularly in regards to the submission of a log sheet and an appraisal index. Well, for those of you who've had a 1-year experience of using the DAPS system, I think you've come to the realization that that's no longer needed, unless you do have a paper submission, which would be really frowned upon, as you know. And we've made some amendments to the under-assessment rules. So let's look at it. In regards to the attorney authorization form, which was formerly known as the owner lexee, I want to make the point that it's one form. It's the board's form. It's not a form that attorneys have somehow felt compelled to alter the language, the format, or anything of that nature. I can't emphasize enough that we will only accept the board's form, not some modification or amendment of the board's form. It's plain and simple. Also, that form is good for the current assessment year, 2016. not 2017, not 2018. We want the form for only 2016. Now, I did mention that one of the forms that we revised was the attorney substitution form. And one of the things we eliminated was there was a redundancy where the taxpayer had to sign twice. And essentially, what needs to be communicated to us with this form is that the taxpayer is letting the board know that they have essentially fired the current counsel, and now it's being replaced with new counsel. That's what we need to know. However, what happens often is that the form is incomplete. It only is executed by maybe the taxpayer and one party. We will not accept the substitution form unless it's fully executed, meaning that both attorneys have to complete the form. Because what has happened in years past is that we end up being some sort of depository for some type of dispute resolution. And that's not our job. It's the jobs of the attorneys to figure that out. So I want to be clear in regards to the substitution form. It has to be fully executed. And then the other thing too is that, and this is something that the Chief Clerk Emmanuel reminded me of, that you also must submit a completed paper complaint form with the substitution form. Now, there's some forms that we no longer need, and I did mention those: the appraisal index, the log, the long form affidavits, and things of that nature. The re-review request form, that's no longer needed because you can request a re-review directly. And I just wanted, this was a very important point, and I just wanted to touch upon it once again in regards to the importance of a attorney account. And particularly, we want to encourage that each attorney that's at the firm have their own account. And the reason being is that you might have an instance where you have one account, and just say you have unfortunate circumstances of that one attorney is suspended, then that will pretty much bar that entire firm from filing. So you want to increase your access as much as possible. And so we, again, would like to reemphasize that each attorney at the firm should have their own account. And these are just some reminders from last year in regards to what's necessary. I think that over the last, say, 2 weeks or so, we received emails in regards to encouraging the practitioners to update their accounts, and that has to be on an annual basis. What we've found is that there are instances where folks weren't in good standing, and they still had accounts. So we have to, or they registered or attempted to register for an account. So this is something that has to be done each year. Now to the good part. In regards to enhancements for 2016, and these are enhancements that directly impact the attorney users, and this will be through the portal. The first one, and I know I will admit I need glasses, but it's looking a little blurry for me. It's just kind of blurry. Okay, so, but what I want to emphasize, what this says, is that in the event that you do receive, you're filing on a parcel that someone else has already filed, you receive a message. Now, the message is not only that there's a due, the message will identify the first filer. Now, the advantages of that is, again, this goes back to the substitution procedure that I described earlier, is that now you can contact that attorney to resolve that situation. Prior to this year, you didn't have the identity of the first filer. Now, you received a notice that there was a due. but you didn't know who duped you. I mean, who you just duped. You just duped the duper or whatever. So that's what that is saying. You'll see it in the event that in your filings there's a duplicate filing. And I think that's a huge plus, and that is something that was requested from the practitioners. And also, when you receive that, and this could be in a situation with a condo filing, where the individual may have filed first, and you filed an entire building, well, this will allow you to continue uploading the evidence. Now, before, once you received the dupe notice, it stopped everything. And that was a major, I would say, complaint from the practitioners. It made sense. So now you receive the notice, but you can continue uploading the evidence. Now, in terms of some of the procedural changes, I mentioned requesting an administrative no change. At finalization of the appeal, you'll receive a box. And you can check that box where, and that's what it is, that's what it says, administrative no change. And that will, in essence, mark that file as a no change 8, and the file won't go into workflow. Last year, even though we were able to see documentation, the letter requesting the administrative no change, unfortunately, those files went into workflow unnecessarily. So I think this is a huge upgrade as well. And we updated the portal home screen, and it's more of a look and feel, nothing to take notes about or anything like that, but we just changed it from the visual. Now, this is something that, again, based on the feedback that we received throughout the course of last year, was this confirmation page. And it's not only telling you that your appeal has been submitted, but it's also giving you a list of the documents that were uploaded associated with that particular document. Now, I had mentioned earlier about the digital signatures. And I won't get into, the formal name is Electronic Commerce Security Act, but there was some confusion in regards to the confusion on the part of the analysts of what constituted a digital signature. And if you can see, font generated by word processing software is not a digital signature. Now, these are examples of digital signatures from different vendors. This one in particular was DocuSign, where the signature is certified and you're able to verify whether or not it's accurate or not, versus a font. And these are just some, we're not endorsing one vendor or another. These are just certain examples of services that provide digital signatures. Once again, the 2016 session is upon us. We are scheduled to open our first group of 8 towns on August 1st. And as you can see, Barrington, Evanston, Cicero, New Trier, River Forest, Riverside, Rogers Park, and Oak Park. Now, this is a change in regards to when you make a request for an oral hearing. You have to make that election at the time of when you finalize the file. Before it was at the time of filing. And see, I think for those of you who've been with us for the past year, I think you have come to the realization that there's no advantage gained from requesting a hearing. There's one evidence submission deadline, and that's it. So we've done away with the phase 2 and things of that nature. So by letting us know at the time that you finalize the complaint that you want a hearing, that's indicating to us that you really want a hearing because there's certain facts that can't be explained simply on the face of the pleadings. And that, I think that's really important, whereas this is kind of bringing it together, whereas there's no doubt that when you finalize the complaint, you're letting us know at that time, I want to hear it. And I want to go back to, in terms of the evidence submission deadline, last year, it was 21 days from the time that the township closed. And that was based on what was primarily, until last year, a very paper-intensive system where gentlemen and young ladies here at the board had to physically match evidence with file folders. They had to locate it and things like that. So that was to allow them the time to do so. What we found is that we've gained certain efficiencies through DAPS, whereas the physical matching of paper to a file is no longer necessary. Also, what we've been looking to do is to improve our scheduling. And with the 14 days, that allows us to better schedule, but also allows the analysts to receive, particularly the commercial analysts, receive the files in enough sufficient amount of time to review all the facts, including the priors, so that they'll be adequately prepared for the hearings. I think that most folks will note that last year, the commercial analysts in their hearings, in some instances, knew more about the file than the attorneys. And so this is this hasn't changed in terms of the scheduling. We rarely had any 8:30 hearings, thank goodness. And this is, again, some of the things that we spoke about last year in regards to the hearings. No more than 10 cases per attorney. Oral argument is limited to 10 minutes per case. And usually the call is about an hour and 45 minutes. This is one of the things that we wanted to talk about, and this is nothing new in regards to the re-review process. We wanted to be known that the re-review process is not an extension of the evidence submission deadline. Oftentimes you'll see a pattern, well, not often, but we've seen it, where certain attorneys never had evidence. And so everything is submitted on a re-review, and we get that there are times where maybe appraiser couldn't get the appraisal back to you by the deadline, but when it's everything is unavailable, then that raises a red flag with us. Also, the review process, and we did revise the Rule 27 last year. There was a big issue in regards to new evidence, new arguments. A review request should be based on that and not, hey, I'm giving you the same exact comps, the same appraisal, everything's the same, I just want you to look at it again. Please be mindful of the fact that re-review is within the discretion of the Board of Review. And so if you see a pattern where someone is on a consistent basis resubmitting the very same evidence over and over and over again, then we could just refuse to even consider any and all reviews from that individual or firm. This is kind of like some practice suggestions. And if you have an appraisal and it's saved in a PDF format, when you upload it, maintain it in that PDF format rather than scanning it, because we have formatting issues on the other end. So if you just give us the PDF that you received, then that'll be fine. Also, please review your result letters as soon as you receive them and check them for accuracy. Yesterday, I received a call about a group 7, and it's July. You know, there's a process that we have to go through, as some of you probably all too familiar with, in regards to the cleanup process. And it's not a very easy process, only because it involves a lot of parties, just put it that, in terms of the CVs and things of that nature. So please make us aware of any issue as soon as possible. And there are times where we might even need a CMB if we knew about it right away. So, like I said, I received a call yesterday about a group 7, and that was 4 months ago. Also, the deadline for subs is the last day of hearings. Thereafter, it'd be the first day of re-review. Now, this is something in regards to affidavits, particularly with dockets that have been presented to the assessor's office. So, for instance, you had a vacancy argument at the assessor's office, and then you make the same argument at the Board of Review, but then that's 4 months later. But you present the same vacancy affidavit that you presented at the assessor's office. So clearly, that affidavit is, I would say, somewhat dated. So we need up-to-date information, particularly when you're talking about vacancy arguments and things like that, because it could have gotten better, it may have gotten worse. We've been talking about paperless, but there's still, we can't get around certain things, and that would be omitted assessments, exempt properties, and undervows that still must be filed in the county. And this is one of the things that we want to, we have to emphasize this every year in terms of the unauthorized practice of law. So we've been very clear on this, that non-attorneys and consultants cannot practice at the Board of Review. And really, if you know of any of that, I think you have a duty to report it. Well, we've come to the end, and thank you. Now, we will open up the floor for some questions. But I'd like to thank everyone for their patience.